In colonial America, under British law, government officials were allowed to search and seize property from people and their homes for no specific reason. This unfair practice was reversed by the Fourth Amendment of the United States Constitution. The first 10 amendments of the Constitution are known as the Bill of Rights. The Bill of Rights spells out the fundamental liberties all Americans have. The Fourth Amendment begins with the assumption that citizens have the right to live free from unreasonable interference from the government. It states, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated." The amendment provides parameters of how, when, and why law enforcement can conduct a search. It says the search and seizure must be reasonable and that there can be no action without probable cause. That means there must be enough hard evidence and information to support the opinion that a crime has been committed. Evidence that would lead a reasonable person to believe that the claim or charge of a crime is true. If these criteria are met, the police can go to a judge and ask for a search warrant. A valid search warrant is a piece of paper issued by the court authorizing a search of a home, car, or other property. The warrant has to be specific and define what police are looking for and where they expect to find it. For example, if the warrant specifically states police can search your garage for a stolen bicycle, they cannot search your bedroom or kitchen. In certain situations, probable cause can be used to justify a search or seizure without a warrant. Law enforcement can override a person's privacy rights if there is probable cause or reasonable suspicion of criminal activity. Still, there must be specific facts. The suspicion cannot be based on just a feeling. The Supreme Court has a long history of upholding citizens' protections under the Fourth Amendment. But in a landmark decision, the court ruled that the law does not apply to students in school. Here's what happened. A high school girl, known only as TLO, was caught smoking in the bathroom. Looking for cigarettes, the vice principal examined her purse and found marijuana. TLO admitted selling drugs at school and was convicted. However, the case was appealed on the grounds that her Fourth Amendment rights had been violated because the school did not have a search warrant to examine her belongings. The case, New Jersey versus TLO, reached the Supreme Court in 1985. The court ruled that school administrators didn't need a search warrant or probable cause before conducting the search. The justices said that while students have a reasonable expectation of privacy, it is the school's responsibility to provide an environment in which learning can take place. They ruled that once school officials have a reasonable suspicion that a school rule has been broken or a student has committed a crime, they can conduct what is called a suspicion-based search. Of course, most searches conducted without a warrant are found to be invalid. Under a principle known as the Exclusionary Rule, evidence obtained in violation of a person's Fourth Amendment rights cannot be used against the suspect. In 1787, when the Constitution was sent to the states for their approval, many were reluctant to sign it. The principal complaint was that there was no listing of the rights and liberties all Americans have. So the creators of the Constitution promised that one of the first acts of the new Congress would be to amend the Constitution to include those rights. At the first Congress, the Bill of Rights, the first 10 amendments to the Constitution, was written and sent to the states for their approval. Among the rights guaranteed by the Bill of Rights are the rights of people accused of crimes. Many of those rights are found in the Fifth Amendment. One right is the protection against self-incrimination. You're probably familiar with the right against self-incrimination, even if you don't know that it comes from the Fifth Amendment. Anyone who has ever watched a police movie or TV program knows these words. You have the right to remain silent. Anything you say can and will be used against you in a court of law. Those words are called Miranda Rights. And while they aren't exactly in the Fifth Amendment, their intention is. that no one can be compelled in any criminal case to be a witness against himself. It protects people accused of crimes from overreaching by the government and lays out the constitutional limits of what the police can do. While the Fifth Amendment was adopted in 1791, it wasn't until 1966 that the Supreme Court ruled on the right against self-incrimination. It happened in the landmark case Miranda versus Arizona. Ernesto Miranda was charged with multiple violent crimes in Phoenix, Arizona. He had less than a ninth-grade education and a history of mental problems. Without an attorney and with no knowledge of his rights, the police questioned Miranda for over 2 hours before he confessed to the crimes. He was convicted based solely on the confession. The case was appealed and eventually reached the Supreme Court, where the conviction was overturned. Chief Justice Earl Warren said the police had violated Miranda's right not to be a witness against himself, a right he didn't even know he had. The decision was also based on the fact that Miranda did not have an attorney. That is a right guaranteed by the Sixth Amendment in the Bill of Rights. To protect the right against self-incrimination, the court created the Miranda Rights and said police must read a defendant who is being held and interrogated the Miranda Warning. Incidentally, Miranda was retried without the use of his confession and found guilty. Another phrase you might have heard is taking the fifth. This means that a person who is being questioned is invoking his or her rights under the Fifth Amendment and will not make a statement or give evidence that might be self-incriminating. There are other rights protected by the Fifth Amendment. One is the right to a grand jury. A grand jury is a group of people who hear testimony from the government and decide if there is enough evidence to bring criminal charges against a suspect. The Fifth Amendment also protects against double jeopardy. That means that a person cannot be prosecuted twice for the same crime. The Fifth Amendment also states that no one shall be deprived of life, liberty, or property without due process of law. Due process means that the government must obey the law and follow all legal procedures and safeguards. When the Bill of Rights was written, the Due Process Clause only applied to actions by the federal government, but that was extended to the state governments by the 14th Amendment, which was adopted in 1868. A final guarantee under the Fifth Amendment does not apply to the rights of the accused, but protects the rights of property owners. It states that if the government takes a person's private property for public use, the property's owner must receive just compensation, fair market value. At the first United States Congress, the Bill of Rights, the first 10 amendments to the Constitution, was written and sent to the states for their approval. Among the rights guaranteed by the Bill of Rights are the rights of people accused of crimes. Many of those rights are found in the Sixth Amendment. One is the right to counsel. The Sixth Amendment states, "In all criminal prosecutions, the accused shall have the assistance of counsel for his defense." In other words, anyone accused of a crime is entitled to have an attorney. When the Bill of Rights was written, the guarantee of rights only applied to the federal government. With the passage of the 14th Amendment in 1868, some of those rights were extended to the states. Up until 1963, the right to an attorney applied only to federal cases and to state cases that could result in the death penalty. Then, in the landmark decision, Gideon versus Wainwright, the right was expanded to include all state felony cases. A felony is a serious crime punishable by more than a year in prison or by death. The case began in 1961 when Clarence Earl Gideon was arrested for robbery in Panama City, Florida. He could not afford an attorney and asked the court to appoint one for him. But the judge ruled that under Florida law, an attorney would only be appointed if the case called for the death penalty. So Gideon was denied a lawyer, and because he could not afford one, he served as his own lawyer at his trial. He was found guilty and sentenced to 5 years in prison. Gideon appealed his case to the Florida Supreme Court, citing his right to have an attorney represent him. Again, the case was denied. In 1963, the case reached the Supreme Court. In a unanimous decision, the court ruled that Gideon's conviction was unconstitutional because he was denied his right to an attorney under the Sixth Amendment. Justice Hugo Black said that the right to an attorney is fundamental and essential to fair trials. Today, anyone accused of a crime that could result in a prison sentence of any length is granted the right to have an attorney. Jurisdictions have public defenders' offices that provide lawyers to defendants. The right to counsel was also extended in another landmark Supreme Court decision. In 1966, in Miranda v. Arizona, the court ruled that a person arrested for a crime has the right to have an attorney present not just at trial, but during the interrogation as well. Under the Miranda Warning, the police must tell a suspect, "You have the right to an attorney during interrogation. If you cannot afford an attorney, one will be appointed for you." The Miranda Warning also protects people accused of crimes from having to give evidence against themselves. That is a right guaranteed by the Fifth Amendment. The first 10 amendments to the Constitution are called the Bill of Rights. They were written to ensure that the fundamental rights of all Americans would be protected. The Seventh Amendment guarantees a trial before a jury in federal civil cases. A civil case is a legal dispute between two parties. The parties can be people, organizations, businesses, or the government. Civil suits usually look for some monetary compensation. One party sues the other for a certain amount of money. Criminal cases, unlike civil cases, are between the government and someone who has broken the law. Criminal suits usually end with a punishment, like a prison term, community service, probation, or a fine. Jury trials in criminal cases are guaranteed by Article 3 of the Constitution. The Seventh Amendment only applies to civil cases tried in federal courts. Each state has its own court system to deal with disputes on a state level. It is interesting to note that one part of the Seventh Amendment has changed since the Bill of Rights was ratified. That is the part that says the right to trial by jury applies when the value in controversy shall exceed $20. In 1791, $20 was a lot of money. Today, the qualifying amount is $75,000. The Eighth Amendment of the Bill of Rights states, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted." Bail is money paid by a person accused of a crime that allows that person to be released from jail until the time of their trial. The theory behind allowing bail is that the accused person will appear in court for the trial because if they do not, then they will lose the bail money. It also acknowledges the concept that people accused of crimes are innocent until proven guilty, and therefore should not be kept in jail without being convicted. However, if a judge decides that the person accused of a crime will either not appear at the trial, that's called being a flight risk, or might do harm to others if not kept behind bars, then bail can be denied, and the person will remain in jail until the time of trial. By saying that bail should not be excessive, the Eighth Amendment attempts to ensure that the amount that has to be paid will not be so great that only the richest people would be able to pay it. The same applies to the stipulation that fines imposed by the government not be excessive. The most widely known and controversial part of the Eighth Amendment is the prohibition against cruel and unusual punishments. What constitutes cruel and unusual punishment has been debated since the Bill of Rights was adopted, and the definition has changed over the years. What is cruel and unusual today was not necessarily considered cruel and unusual at other times. The major point of debate is capital punishment, the death penalty, which can be imposed for espionage, treason, and murder under a variety of circumstances. Various cases concerning capital punishment have been heard by the Supreme Court, which has ruled that the death penalty is not cruel or unusual as long as it is conducted according to certain guidelines. For example, the guilty person must be mentally competent and over the age of 18, and the court has said that there must be 2 jury hearings in capital cases, one to determine guilt or innocence, and one to determine the sentence for a defendant found guilty. The Eighth Amendment prohibition against cruel and unusual punishment doesn't only apply to sentences imposed on the guilty. It also applies to the way prisoners are treated. For example, the use of solitary confinement, protections for the health and safety of prisoners, and the physical conditions of prisons. What constitutes cruel and unusual punishment is an issue that continues to be debated and discussed, and will most likely continue to change, as it has, over time.